Hi everyone, so welcome to this new video and in continuation with the series that we are already doing on the articles of the Constitution of India, we'll now be continuing with articles 12 to 35, which is part 3 of the Constitution of India, and it deals with fundamental rights. Now as you can see that the topic is very important, as well as there are many articles and probably all of the articles are very important to get covered. So we'll not be able to do this in one video, and I'll make separate videos, maybe 2 or maybe 3. I'll try to fit in all these articles in 2 or 3 videos. So this is the first in the series of fundamental rights, and we are starting our discussion with Article 12. Till Article 11 we have already done in the previous videos. Now Article 12 talks about definition. Now the definition of what? So it is talking about the definition of state, and this says that unless the context is otherwise specifying, the state for this part means fundamental rights. So the word state would include the government and parliament of India, the government and legislature of each of the states, and all the local or other authorities within the territory of India. Okay, within the territory of India, all the local or other authorities or under the control of the government of India. Okay, so this was the definition of state. Then when we talk about Article 13, it says laws inconsistent with or in derogation of the fundamental rights. Now, what are the laws which are considered as inconsistent with the fundamental rights or which are considered as in derogation of the fundamental rights? So, the first clause says that all the laws which are in force in the territory of India immediately before the commencement of this constitution, इस कॉन्स्टिट्यूशन के कमेंसमेंट के इमीडिएटली पहले जितने भी लॉज इन्फोर्स हुए हैं टेरिटरी ऑफ इंडिया में, in so far as they are inconsistent with the provisions of this part. So जिस extent तक वो laws inconsistent हैं इन provisions से, उसी extent तक वो चीज़ें void कहलाएंगी. ठीक है, वो null and void मतलब उसको माना नहीं जाएगा. That will not be considered. So suppose this is a law and there are certain provisions, 4-5 provisions. Now if 2 of the provisions are not in consistency with the provisions of this part, the fundamental rights, which the constitution is specifying. So constitution बनने के पहले कुछ मान लो एक ऐसा law था जिसके कुछ provisions हैं, and some of the provisions are not in consistency with this particular part, तो उनको void माना जाएगा and rest of the things would be taken care of. Another clause of this Article 13 says that the state shall not make any law which takes away or abridges the rights conferred by this part. So इस part से जो भी लोगों को rights मिल रहे हैं, states ऐसा कोई law नहीं बनाएंगे जिससे वो rights छीन लिए जाएं, ठीक है? And ऐसा कोई भी law and any law which is made in contravention of this clause, इस clause के against जाके अगर ऐसा कोई law बनता है तो वो भी void कहलाएगा. जिस हद तक वो गलत होगा, जिस हद तक वो contravention में होगा, वहां तक उसको void माना जाएगा. So which means कि not the entire law would be considered as void, but to the extent it is not going in consistency with the provision or it is in contravention to the clause. ठीक है. I would also request you, I just forgot to say that in the beginning, please have a copy of the constitution with yourself, hard copy or soft copy, so that it would help you relate the articles very easily. The third clause, which is Article 13, Clause 3, it says, in this article, unless the context otherwise requires. So we are talking about which article? Article 13. Unless the context otherwise requires. Law. So there is this term which would be used. Law would include any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. Okay. And second, the term is laws in force, which includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed. तो अगर ऐसा कोई भी लॉ है जो लेजिस्लेचर से पास हुआ है या बनाया गया है और इवन बाय सम कॉम्पिटेंट अथॉरिटी इन द टेरिटरी ऑफ इंडिया कॉन्स्टिट्यूशन के कमेंसमेंट से पहले और उसको पहले अगर रिपील नहीं किया गया है, ठीक है, तो दैट वुड बी कंसिडर्ड एज लॉज इन फोर्स. and this should either be in operation either at all or in particular areas. And it also says that nothing in this article shall apply to any amendment of this constitution made under article 368. So whatever in this particular article 13 की जो हम बात कर रहे हैं, so anything which we are talking, these things or these things, these are not going to be considered as any amendment to the constitution, because all the things related to the amendment of the constitution, basically it is covered in article 368. There are certain other aspects also which are not covered in article 368, which are also considered as amendment. That will be seeing as we go across all the different articles, but basically with particularly we are talking about article 13. So anything which is there in article 13, it is not considered as amendment to the constitution under article 368. This was all about article 13. Now when we start discussing about right to equality, we'll be discussing from articles 14 to 18. Okay. And I think from here on, after like 18, from article 19 onwards, we'll be seeing in another video. So we'll only be doing right to equality here. Article 14, the first one in right to equality. It says equality before law. Now before we start this, you need to remember that there would be certain articles, especially when we are talking about fundamental rights, which would be there for citizens. Citizens would be the citizens of India. There would be certain articles which would be for all the persons. It would include the citizens and the non-citizens, which are the aliens. Aliens would be the citizens of another country. ठीक है, तो ध्यान आपको ये देते जाना है हर आर्टिकल के साथ दैट कौन सा वाला पर्सन्स के लिए है, कौन सा वाला सिटीजन्स के लिए है. तो आर्टिकल 14 इज फॉर द पर्सन्स, एवरीबडी. ठीक है, सो इट इज इक्वालिटी बिफोर लॉ एंड इट सेज द स्टेट शैल नॉट डिनाई टू एनी पर्सन equality before the law or equal protection of the laws within the territory of India. So ये दो चीज़ें आपको याद रखनी है. In the book Lakshmikant, so if you are having the latest 6th edition, I'm giving you the page number. So this is on 7.4. ठीक है, 7.4 of the 6th edition of Lakshmikant, wherein they have described right to equality in greater detail, and you are seeing the details of both equality before law and equal protection of laws. So I request you to please go and check the details, because here we are just doing the articles of the constitution. So every bit of that won't be able to discuss. Okay, so just check that 7.4. Next is about article 15. It says prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. So the first important point, the first clause also says that the state shall not discriminate. So it is talking about discrimination. It shall not discriminate against any citizen. First of all, it is not about persons, it is about citizens, on the grounds only of, what are the grounds which are considered here? Religion, race, caste, sex or place of birth, or any of them. Okay, this is first. Second, no citizen shall, on these grounds, so no citizen shall be subjected to any disability, liability, restriction or condition with regards to किन की चीज़ों के लिए? एक्सेस. तो किसी भी तरह का डिसेबिलिटी या लाइबिलिटी या रेस्ट्रिक्शन नहीं होना चाहिए लोगों को इन दीज थिंग्स. और एक्सेस कहाँ कहाँ की बात कर रहे हैं? शॉप्स, पब्लिक रेस्टोरेंट, होटल्स, पब्लिक एंटरटेनमेंट प्लेसेस एट्सेट्रा. सो इन ऑल दीज प्लेसेस यू शुड not discriminate on the basis of liability, restriction या कुछ भी. Then use of wells, tanks, bathing ghats, roads, places of public resort etc. ये सबको allowed होना चाहिए, which is dedicated to the use of general public or which is maintained wholly or partly out of state funds. So these there should be no discrimination in the usage or access of these things. उसके अलावा it says, now this is a very important provision, the clause. It says that the state can, it reads like, nothing in this article shall prevent the state from making any special provision for women and children. So states किसके किसके लिए special provision बना सकती है? Women के लिए, children के लिए. Apart from that also the state can do it for, like the special provisions can be there for socially and educationally backward classes of citizens or for scheduled caste and scheduled tribes. So states इनके लिए भी special provisions बना सकती है. Now the point is that इनके लिए special provisions कहाँ बनेंगे? Admission to educational institutions में. ठीक है, educational institutions में admission के खातिर आप इनके लिए special provision state बना सकती है. Now these educational institutions would include the private educational institutions and these could either be aided by the state or unaided by the state, which is okay. Okay. However, it says that these institutions should be other than the minority educational institutions, जो आर्टिकल 30 क्लॉज 1 में बात की गई है. So when we'll be seeing article 30 clause 1, we'll understand about the minority educational institutions. But apart from that, you know, the different educational institutions, including the private ones, aided or unaided, everything is covered for the special provisions with respect to socially and educationally backward classes, or for SCs and STs, scheduled castes and scheduled tribes. Then we see clause 6, which is a recent addition. So it was added by 103rd Amendment Act 2019. So it says about the special provision for the advancement of economically weaker section, EWS, economically weaker section. 10% reservation आप इनको दे सकते हैं, ठीक है, maximum 10% reservation. What is to be remembered is that this 10% reservation would be given in addition, ठीक है, in addition to the 50% of the reservation जो existing है अभी के समय में 50%, उसके एडिशन में मैक्सिमम आप 10% का रिजर्वेशन दे सकते हैं, ठीक है. एजुकेशनली वीकर सेक्शन, सॉरी इकोनॉमिकली वीकर सेक्शन को EWS. एंड अगेन द this thing applies that the admission to the educational institution, including private, aided or unaided. And here also the minority educational institutions जो 31 में बात होगी, that is not covered. So this was about Article 15. Next, when we talk about Article 16, we see equality of opportunity in matters of public employment. So it says again, now it is for all the citizens here, not for persons but for the citizens. तो यहाँ पे क्या क्या बातें हो रही हैं? Employment or appointment to office under the state. And this says क्या क्या grounds cover होंगे? Religion, race, caste, sex, descent, place of birth or residence. So here the grounds were religion, race, caste, sex और place of birth. ठीक है, ये कुछ अलग criteria थे. यहाँ पे there are different things also, religion, race, caste, sex, descent, place of birth and residence. इस basis पे आप on these grounds you have to consider कि कोई discrimination employment या office में जो है वो नहीं हो सकता है. But what it is also telling about that nothing in this article shall prevent the parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office, which is about the residence within a state prior to such employment or appointment, which means that parliament can prescribe residence. ठीक है ना, यहाँ जैसे रेसिडेंस की बात हुई है तो ये कह रहे हैं कि एज अ कंडीशन वो रेसिडेंस को एक कंडीशन दे सकते हैं फॉर सर्टेन एम्प्लॉयमेंट अपॉर्चुनिटीज और अपॉइंटमेंट इन अ स्टेट और यूटी और लोकल अथॉरिटी. बट अभी के लिए प्रेजेंटली इट इज़ नो सच प्रोविजन इज एग्जिस्टिंग बिकॉज वो 1974 में दैट गॉट एक्सपायर्ड. सो प्रेजेंटली एज फार एज व्हाट द लक्ष्मीकांत इज सेइंग दैट इट इज़ एप्लीकेबल ओनली इन द स्टेट्स ऑफ आंध्र प्रदेश एंड तेलंगाना, रेसिडेंस वाला क्राइटेरिया, ठीक है, अदरवाइज इट गॉट एक्सपायर्ड. Apart from that, it also says, we are still talking about Article 16, another clause talks about the provision for reservation of appointment in favor of backward classes of citizen. ठीक है, उसके अलावा आप SC/ST के केस में आप seniority के लिए भी दे सकते हैं, ठीक है, in the matters of promotion. So it is also telling that a law can the state can provide for reservation in the matters of promotion with consequential seniority. कुछ पोस्ट के लिए जो शेड्यूल कास्ट और शेड्यूल ट्राइब के लिए होंगे इन द जो स्टेट के नज़र में जो होगा इन द ओपिनियन ऑफ द स्टेट विच आर नॉट एडिक्वेटली रिप्रेजेंटेड इन द सर्विसेज. अपार्ट फ्रॉम दैट देयर इज ऑल्सो समथिंग अबाउट द वैकेंसीज. So it is talking about the unfilled vacancies. So what it is telling that the state is allowed to, it is permitted to consider any unfilled vacancy of a year जो उस साल में रिजर्वेशन के लिए रखी गई थी. सो उस अनफिल्ड वैकेंसी को भी स्टेट कंसिडर कर सकती है इन अकॉर्डेंस विद एनी प्रोविजन फॉर रिजर्वेशन जो पुराने क्लॉजेज में बनी हुई हैं एज अ सेपरेट क्लास ऑफ वैकेंसीज टू बी फिल्ड अप इन एनी सक्सीडिंग ईयर. आने वाले साल में भी उस वैकेंसी को वो भर सकती है, ठीक है. एंड दिस इज नॉट इम्पॉर्टेंट टू कंसिडर देम एज अ टुगेदर टू कंसिडर दीज वैकेंसीज टुगेदर विद द वैकेंसी ऑफ द करेंट ईयर, क्योंकि वो 50% जो सीलिंग डेटा माइन कर रहा है जो प्रेजेंट सीलिंग है एंड 10% एक्स्ट्रा EWS का, इसको ध्यान रखते हुए वो पुरानी अनफिल्ड वैकेंसीज को भी कवर करवा सकती हैं. Apart from that, another clause talks about the incumbent of office. ठीक है, incumbent of office मतलब those who are presently holding the office. So what they are telling कि if there is anything about any religious or denominational institution और किस कोई member की अगर हम बात करते हैं of a governing body of those kind of particular institutions, so the state by law it can provide कि कौन उसको ऑफिस को होल्ड करेगा if it is about any religious or denominational institution. Apart from that, the state is also permitted to make a provision for the reservation of up to 10% appointment. जैसे इसके पहले वाले में था 10% EWS के लिए. So this is also a newly added clause. So it also talks about the 10% reservation for appointment or post in favor of any EWS, economically weaker section of citizens, other than the classes which were mentioned in clause 4. ठीक है, and it also has to be in addition to the 50% reservation. और ये जो EWS criteria है, the state would be notifying it on the basis of income and such other parameters. The state would from time to time notify that who are the ones who would be coming under EWS criteria. ठीक है, so 10% यहाँ पर भी है, उसमें भी था. Now when we talk about article 17 and 18, so article 17 talks about abolition of untouchability, and I think this question has been asked also recently in the exam, that abolition of untouchability is covered under which of these articles, like right to equality, freedom, etc. So the answer would be equality. So untouchability is abolished and its practice is any form its practice in any form is forbidden, allowed नहीं है, ठीक है, मना है. So it is prohibited, abolished. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. तो अगर ऐसा कोई चीज़ होता है, कुछ ऐसा कार्य किया जाता है जहाँ पे untouchability की वजह से कोई disability हो जा रही है किसी को, तो that would be a punishable offence. Apart from that, Article 18 talks about abolition of titles. So it says that no title, not being a military or academic distinction, ठीक है, मतलब I'll just show you, military or academic, these distinctions would be allowed, but except the military or academic distinctions, no title shall be conferred by the state. State और कोई title नहीं दे सकती है. Also, no citizen of India shall accept any title from any foreign state. कोई foreign state से भी citizen किसी तरह का title accept नहीं कर सकता है. No person who is not a citizen of India. So any person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. So anybody who is not a citizen of India, but if they are holding any office of state, any office in state of India, so if they also have to get any title from any foreign state, that would only be allowed only if you have the president's permission, okay, consent I mean. It also says no person holding any office of profit or trust under the state shall without the consent of the president accept any present, emolument or any other kind of office from or under any foreign state. So इन सब चीज़ों के लिए आपको क्या चाहिए, आपको चाहिए president का consent. Only then you would be allowed to have any titles. Otherwise सिर्फ military academic distinctions such kind of titles are allowed by the state, and everything else is just abolished. It's not allowed. So this was all about right to equality till article number 18. From 19 onwards we'll be seeing in the next video. In case you are liking these videos and if they are helpful to you, please do subscribe to the channel, like, share and comment as well, so that I understand how am I going. So thank you so much guys. Please do not forget to check the Anjan Kalash videos. They are being constantly updated on the different social media platforms. Environment series is going on as of now. History and polity have been done. I'll also be experimenting with the new things and coming up with new such videos on different topics. For the time being, I'll just take your leave. Thank you so much. Take care. Bye bye.